I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on state open meeting laws. As a reminder, all of our classes build off one another. So if you haven't already, please view our previous lessons on open meetings and executive sessions. They'll give you a good overview of the law and lead into what we'll be discussing today. We also have a growing library of lessons on state public record laws and the Federal Freedom of Information Act. All these lessons can be found on our YouTube channel, as well as in our FOI guide at nefac.org/FOI guide. Before we begin this lesson, a special thanks to those helping us make these classes happen. The Society of Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on state open meeting laws. Now, this session here is going to focus on citizen participation in government meetings in Connecticut. And with us is Bill Fish, and he's going to explain about making comments during open meetings and give some tips and advice for citizens who'd like to make their voices heard at those meetings. Bill, thank you so much for joining us today.
Emily, thank you very much, and thank you for the introduction. I am going to speak today on the right of the public to participate by making comments in public meetings. But before I do that, I'm going to set the stage a little bit. And Connecticut is a little bit unique compared to many other states, certainly in New England. Excuse me. And we have what's called a Connecticut Freedom of Information Commission. And that commission is an administrative agency here in Connecticut that is charged with enforcing the Freedom of Information Act. And what that does, and this is really important for people in Connecticut, you do not have to go to court in the first instance if you want to enforce your rights under the FOIA. Instead, you get to go to this administrative agency. And one of the beautiful things of that is you don't need somebody like me to be your lawyer because you can do it on your own. And the commission actually helps people and works to try to resolve matters. So if you were dealing with a public meeting that somehow you didn't have the right to speak at, or you did something you weren't able to get access to an agenda or whatever, you could go to the commission and try to deal with that. Or if you were trying to get a public record and you couldn't get it, which is probably more common, you could go to the commission and they could try to help you work through that. So the commission is a very important part of the FOI here in the Connecticut landscape. In order to really focus on the right to comment and participate at a public meeting, we have to start with what is a public meeting. And that is defined in our Freedom of Information Act. And I don't want to take the time to get into all the detail of it, but if you're dealing with a board of selectmen, a board of education, a board of finance, and the members of that board are getting together, that will be a public meeting. And we need to, for purposes of this talk, distinguish that from what I'll call a public hearing. And a public hearing, for purposes of today, would be more like a quasi-judicial matter. If you think about a zoning hearing or something else where there are due process rights involved and evidence being presented, that is also technically a public meeting under the FOI in Connecticut, but it's really not the type of meeting where people come to comment, because there you have these other substantive rights in play. And if we were to try to talk through all of those, we could be here for hours. So what we're really going to focus on are the kind of the regular, I'll call it public meeting, think Board of Finance, think Board of Education again, where there's an agenda, the board is acting, and as a citizen, you want to stand up and have your voices heard. Sort of cutting to the bottom line in some ways, in some states, in the FOI or in some other statute like the FOI, there is a statutory right for the citizen to comment and make their voices heard at a public meeting. That is not the case in Connecticut. The FOI, like many other states here in Connecticut, does not have a statutory right in the FOI for a citizen to speak. Instead, the FOI has recognized that the government is essentially owned by the people, it's for the people, and therefore you have the right to watch and to listen to your government in action. So you get the right to go to a public meeting, you get the right to sit there and listen, but you do not have the right to participate under the FOIA. So that's a very important point there, because if, in fact, if you try to enforce a right to make public comments, and you went to the FOIC, that administrative agency, and you asked them to do that, they would tell you, and they've done this more than a few times in a written decision, there's no right to public comment under the FOIA. Now, that doesn't mean that the FOIA doesn't have many other important rights that very much relate to this. So let me just kind of go through this litany of rights. You have the right to notice of a meeting. That could be posted someplace. It also could be the type of thing, if you're very interested in your local Board of Education, you could request notices of every meeting, and they would have to give you notice of the meeting. You have the right to see the agenda in advance of a meeting, so you know what they're going to be talking about, so you can make a decision whether you want to be there or not. You get copies of the minutes, so you can see what happened. You're entitled to see what votes were taken. All of these are things that the FOIA provide for here in Connecticut. You also have the right to record the meeting. So if you were sitting there in the meeting, you could turn on your phone or whatever other equipment you have, and you could record the meeting. That also gives the right to the broadcasting entities out there to record the meeting. I remember many years ago, I was in sort of a high profile hearing before the FOIC. I'm sitting there at the table and I got all my papers there, and the TV news people came in, and I actually almost represent all these entities anyway. And the guy put his camera, or his, not his camera, his microphone's flat down right in front of me, right on my papers. And it's like, what are you doing? And so I had to move his microphone over, and then he had to move it back a little bit to show he was in control. But they have the right, everyone has the right to record public meetings. You just can't disrupt them. So you can't do things that would be disruptive in that regard. But as I said, the biggest thing is the right to attend, to watch, and to listen. Now, when you walk in the door of public meetings in Connecticut, occasionally you get confronted by a sign-in sheet. You got to write your name and whatnot. That's actually not allowed in Connecticut. It happens more than a little bit, but it's not something that a public agency is allowed to do. They cannot ask you or require you to put your name down or any other identifying information as a right or as a condition to come into the meeting. So you have the right to listen. You have the right to watch people. And that's now changed a lot, right? Doing what we're doing right now with this the Zoom call. Before the pandemic, we hardly knew what these things were. But Connecticut has adopted and has put in place, effectively permanently now, new laws that deal with remote meetings. And the biggest issue there is, if people are going to participate in remote meetings, you need to make it easy for them. And so now we have the right to get notice of remote meetings and how the public can listen to remote meetings. Now, even though there's no, in this long litany of rights in the FOIA, the right to participate by speaking at a public meeting, that landscape could change. And last year, 2022, the Connecticut House did not pass, but they put on the floor a bill that actually inserted such a right into the FOIA, where there'd be a statutory right, like I think one of our other sister states here in New England has, to participate and to give comment at a public meeting. It did not get adopted. So at the moment, there is no such right, but that easily could change in the not too distant future. I mentioned the remote meetings, and there's actually language at the end of the new statute that deals with that says nothing in this section shall be construed to require a public agency, which is your board, your commission, to offer members of the public who attend a meeting by means of electronic equipment the opportunity for public comment, testimony, or other participation if the provision of such opportunity is not required by law for members of the public who attend such a meeting in person. In other words, even though you have the right to do this remotely, the FOIA has made it crystal clear that you do not have the right under that statute to participate. Now, having said all of that, as probably everyone who's listening knows, it's quite common for public agencies to allow and to actually want public comment. The public agencies, if they're doing their job properly, they understand they're doing the public's business. They understand that what they're doing is trying to work with their constituents, and receiving public comment is obviously a very big part of that. So it's very, very common to have a public comment section on an agenda. I was the chair of the Board of Education for a while, and that was on our agenda every meeting without fail, as far as I can remember. And there's some towns in Connecticut. We have 169 towns in our small little state. There's some towns that actually strongly encourage this, and they have memos or directives to their different boards and commissions, strongly encouraging them to have public comment sections. Other boards just do it out of past history. It's always been that way. It kind of just gets passed down from board to board and then chair to chair. In other towns, it's left up to the individual chairperson to decide, are we going to have a public comment session or section on our agenda or not? Now, this is important. Once you do allow a public comment section, then the First Amendment kicks in. And there's probably the same rule under our Connecticut Constitution would also kick in, although there's very little jurisprudence that supports that. But it almost certainly would be the same thing. And that's because if you're going to allow comment, then you're effectively creating a limited public forum. And if a town board or commission does that, that brings into play a whole bunch of First Amendment related concepts and rules. One of the simplest ones to articulate is if you're going to do that, allow people to comment at a public meeting, you can't condition the comments on the content. In other words, if there was, say, a particular agenda item and you could be for it or against it, you can't say, if you were going to allow public comment, but we're only going to allow people to speak for it, we're going to not allow people to speak against it. That would not be permitted under the First Amendment. If you're going to open it up, you have to open it up for everybody. And you can make, if you're in this situation where you're doing public comment, reasonable time, manner type rules to control it. Just because you open it up for public comment, if you're the chairperson of the board, for example, it doesn't mean you have to allow everybody to speak for hours on end. You can say, okay, we're going to limit public comment to no more than 3 minutes, 5 minutes, whatever you think is reasonable under the circumstances. That would be a reasonable time restriction, as contrasted with, excuse me, what I said a moment ago, where you were going to restrict comments by only allowing people on one side of the issue to speak and not people on the other side of the issue. You also would have to be very careful about this. You can limit your speakers to just things related to your agenda or to your jurisdiction. If, again, I keep going back to the Board of Education because I'm very familiar with it. If we're having a public comment section on the agenda for Board of Education, we can say we're only going to hear things that are related to what the board does. So if a particular speaker wanted to talk about, pick your topic, the Russian invasion in Ukraine, which has nothing to do with what the board has jurisdiction over, you could say, no, we're not going to let you talk about that. One of the things that a board would have to be very careful of, and in practice, this is hard to do, is if you let somebody go on, notwithstanding that it's off topic or off the jurisdiction of the board, and speak about something, you've opened the door. And now if you want to try to tell the next person who wants to go kind of off topic, if you will, from the board's jurisdiction and talk about something else, that now you've really opened it up, and you can't close that door again. You have to be very careful about that. Now, if you're looking to make public comments, generally it makes much more sense, obviously, to be commenting on things that the board has jurisdiction over. But the board does have the ability to limit those topics in that way, as long as they do it properly. We've also heard or read in papers about how meetings can get very unruly all around the country. Tensions run high. They certainly can in all sorts of situations. It is permissible in Connecticut, if things get out of hand, under the FOI, to remove somebody from a meeting. So if you want to deposit a simple example, not even in a public comment section, if somebody in the back of the room is shouting and saying all sorts of things while the board is trying to conduct its business, and that person, by doing that, is disrupting the ability of the board to conduct its business, the Connecticut FOI allows the board to remove that person from the room. Obviously, that could be not the simplest thing to do as a matter of practice, but the statute permits that. You can go so far under the Connecticut statute, if it gets completely out of hand, you can clear the room. You can actually say, okay, we're stopping the meeting. It could be clear the room, or the board could actually go someplace else, of course, right, and physically continue in a different spot. If you do that, and I will tell you, I think I've heard of this once in Connecticut. It's very rare. But if you do that, you do have to allow the media to stay in the room, as long as the media was not part of the disrupting. And then you also have the ability to readmit people who are not part of the disruption. So there is a process to do all of that, all in the Connecticut FOI. If you sort of take those types of concerns and bring them into the First Amendment issue, you can come up with all sorts of different scenarios where people disrupt meetings or say things that might be considered defamatory about members on the board, about other people. In my view, what a board should do in that circumstance is simply, politely listen, and unless the situation gets really out of hand, where it's really a threatening conduct or something like that, not try to censor or somehow stop the person from speaking. So if you are a person looking to make what I would call sort of regular comments to a board on an issue that a board has jurisdiction over, and they open it up for public comment, other than limiting your sort of time, which they would have the right to do as long as they did it for everybody, you should have the right to make those comments. And if they don't allow you for some reason, because they think you're speaking on the wrong side of the issue or something like that, that would be a violation of your First Amendment rights in that context. So it's a little like a door opening. That once the door opens and public comments are permitted, and if they're permitted to go far afield, you would also be allowed to go far afield. And once the door opens, it's very hard for a board to shut that. So again, if I could just sort of summarize, let me say it differently. If you look at these issues, in a lot of times, it's really kind of case by case. If you want to say something and it goes a little far afield and the board tries to shut you down, could they do that? Should they have done that? Probably not, but it's always going to depend on the facts and circumstances. But just to repeat myself a little bit, because it's such an important point, if you are looking to make a public comment at a board meeting or a commission meeting where they have opened it up and allowed public comment, and you wait your turn, you, under the First Amendment, would have the right to say your piece to that board on issues that pertain to the topics at hand. Earlier, I said if you want to attend a meeting under the Connecticut FOI, the board does not have the right to ask you for your name or any other identifying information to attend the meeting. It's a little different if you're going to make a public comment. It's very traditional, and there's nothing wrong with conditioning the public comment on, tell us who you are. I mean, I think that's a reasonable thing for a board to do. And in practice, nobody really, has much of an issue with that. So if I were to summarize all of this, there are many types of hearings in Connecticut. To go back to the beginning of what I said, where I would contrast hearing from a public meeting, there are many hearings in Connecticut where there are substantive rights in play, where people have a right to speak. But if you put those on the shelf and now look just at public meetings, the kind of regular meetings I've been speaking about, there's no right under our statute, under our FOIA, to participate in a public meeting. You get to listen, you get to watch, you get to record. But if the public agency, that the board or commission, does what almost most every board does, which is allow public comment at some point on the agenda, then you do have a right to speak. And that's when the First Amendment kicks in and gives you First Amendment protection in order to say your piece to the board within the reasonable constraints, the reasonable and fair constraints that the board adopts. And finally, just to repeat myself, at some point, somebody could disrupt the meeting so badly that under Connecticut law, the board can take extreme action and try to do things to continue on with the public's business. But it's so rare, it almost never happens. So, Emily, that is my summary of Connecticut. Hopefully someday it'll be more in depth, because we'll actually have a statute that says the public does have a right to participate, but we are where we are today.
Somebody asked a question during your presentation that I can read to you,
Okay.
if you
I'd be
like.
happy to try to answer it.
All right. So what can I do if I'm censored by a government official on social media? For example, if you can't be physically present at a meeting and ask questions before the meeting, commenting on a government Facebook page, announcing the meeting, and the comments are deleted. So it sounds like they asked a question on the Facebook page and then they disappeared instead of getting answered.
That's a great question, and I'm going to confess I'm not sure I know the answer to that. I don't think that would implicate the FOI, because it's not the question isn't being asked in the context of a public meeting. Most websites like that, and I'll call it a website for the moment, do have rules that allow them to, take down certain things, if they're not appropriate. Whether this particular posting went outside the rules or not, I guess would be a fact question. But I'm afraid, Emily, I'm not going to be able to do a great job answering that one. It's a little outside of my expertise.
Yeah, no, it's definitely an interesting question, that's for sure. And Bill, thank you so much for walking us through this. I really appreciate it.
No, it's my pleasure. And I echo checking out those other videos. I've watched a series of them, and they're great.
Excellent. All right, well, hey, thanks everybody.
Take care.